In news back home, the African National Congress could face more fraud charges if it has been deducting unemployment insurance fund contributions from its workers without paying them over for the past 3 years. ANC staff downed tools last week as they have not been paid for 3 months. Staff also claimed that the party had made UIF and provident fund deductions, but that these were not paid on the relevant entities. Advocate Modidima Mannya is a legal analyst and public commentator, joining us as well as Hefferman, labour law expert from Hefferman Attorneys. A very good evening to you both, and thank you so much for speaking to us.
Good evening.
Good evening. Thank you.
Okay, Advocate Mannya, let me start with you. If you look at a payslip and if UIF has been deducted, but there's no evidence that it's been paid over to you, does that mean the employer clearly pocketed the money? Is this a safe deduction?
Well, firstly, I think we need to explain and contextualize. The obligation to make certain statutory deductions is that of the employer. And by operation of law, that creates a relationship between the employer and the state and the entity, in particular, in this case, the UIF. Now, the deductions in law are made and intended to be paid over to the UIF. And if they are not paid, it means the employer is non-compliant. It does not necessarily presuppose theft or fraud. Of course, the fact that the money has not been paid earns the employer some penalties because there are penalties in law, but not always that the deductions have not been paid over, that the employees would be penalized. It's not the employees who would be penalized, it would be the employer who would be penalized.
All right, let's hear from you, Mr. Hefferman. What do you consider then in this case as constituting fraud and whether it should result in a criminal charge?
Well, it's straightforward. The unemployment insurance system in South Africa is governed by the following legislation. Firstly, the Unemployment Insurance Act of 2001, commonly referred to as the UIA Act, and secondly, the Unemployment Insurance Contributions Act 2002, also referred to as the UIA Act. So these acts provide for the benefits to the contributions of employers that should be followed, and the imposition and collection of the contributions to the UIF respectively came into contribution into operation on the 1st of April 2002. So should an employer not follow that, it constitutes a violation of Chapter 17 of the Tax Administration Act of 2011 that deals with offences committed under the Tax Act, which also applies to the UI.
Okay. So at what point would you say then it constitutes fraud and it should therefore lead to criminal charges?
Well, I can't really say. It might be that the employer has got an arrangement with SARS. Might be that they don't have. If they don't have an arrangement with SARS, it constitutes fraud.
Okay. Advocate Mannya, let's come back to you. If it is found that payments were not made, can the party fix it in retrospect, as in back pay the outstanding contributions to the Labour Department?
Yes, they are obliged to pay that money. If that money has not been paid, they remain obliged to pay it over, and it will come with penalties, and there will be other sanctions for non-compliance.
But then how would the Labour Department, for instance, determine if it's something that is worth facing sanctions over? What questions would have to be answered? In this case, we're talking about the ANC. Advocate Mannya?
Well, the first question is, were you required to make a deduction and pay it over? And if the answer is yes, then you were obliged to pay over. And if you didn't pay over, you have contravened the act. That's the first thing. The second thing, obviously, would have to be an inquiry, what happened to the money? It may as well be that somebody stole the money, even unbeknown to the employer. Or it may be that the employer used the money for a purpose unintended. Now, when you talk about fraud or you talk about theft, you're talking about a criminal offense, and amongst others, you have to prove intention. And of course, if intention is proven, then it will be a criminal offense, whatever criminal offense people are charged with. But I must also indicate that, often, even in terms of tax, people do default for various reasons, and they do make representations. So it is a bit dangerous to simply characterize this as fraud and theft. And I think the proper process of investigation will establish the actual circumstances under which the money was not paid and who should be held responsible.
No, absolutely, which is why we're asking broad questions to understand this. Mr. Hefferman, I'd like to hear from you another possible case. And as we say, we're not presupposing that this is the case, but it seems the ruling party may also face charges of contravening the Unemployment Insurance Contribution Act and tax laws after the Democratic Alliance opened a case against the ANC and the top six. What would they have to prove?
Well, at the end of the day, as my learned colleague said, it goes about the intention. Firstly, you have to establish in any criminal charge or statutory defense whether they had the intention to contravene the act. And then you have to look at reasons. And I don't know. I can't say for a fact whether they have made representations to the governing body. I don't know. But yeah, if you don't follow these regulations, it's a contravention of the Tax Administration Act of 2011.
Okay, and this, of course, has to do with pay-as-you-earn tax. Let's move on to another matter now. Advocate Mannya, I'd like to get your thoughts on allegations that some members of the National Prosecuting Authority apparently acted improperly and revealed the former President Jacob Zuma's medical records. Just talk us through your thoughts about this matter being raised, and how plausible is it? If so, what should happen?
Well, Tsepiso, I think and I keep on saying that we are operating under very difficult circumstances as a nation. Remember, we have a history that the National Prosecuting Authority has always been accused of things. We also know that when the current president took over, he had to stop the appointment of some of the deputy directors of national prosecutions, and there has been litigation around that. And there has been a lot of suggestions about their appointment. We also know that there is a process to bring the National Prosecuting Authority back to real life and to have it regain its trust and confidence by the public. At the same time, we know that the issues around former President Zuma have been matters that have attracted national debate, controversy, and all sorts of things. But having said that, it's important that we emphasize the principle that everybody, regardless of whether we like that person or not, has got the right to have his or her dignity and privacy protected and secured. But at the same time, you must understand that information leaks all the time. And some of the information that leaks tends to prove impropriety. And I don't think that we want to be a nation that punishes people who expose impropriety, whether by way of leaking information or reporting it. But at the same time, the situation currently in the ANC is a bit toxic. The ANC is going through a difficult time, and you can see the very pronounced allegations and counter-allegations. But the most important thing with the allegations against the NPA and its officials is that we need actually those who are making the allegations to provide evidence, because it seems like we are constantly and persistently dealing with innuendo and suggestion.
Okay, I'm going to stop you there, Advocate Mannya, because we are running out of time, and I really need to allow Mr. Hefferman to have his say on this matter. If if, the president is approached with such, is it prudent for the president to be entertaining a letter from former President Jacob Zuma's lawyers to look into the NPA? Some would say this is interference. What are your thoughts on this, Mr. Hefferman?
Sorry, my speaker was muted. It is possible at the end of the day. That's what I'm saying.
Okay, so I'm talking about allegations that the NPA may have acted improperly. This has been brought to the attention of the president, we believe, through the former president's lawyers, asking him to intervene. Would this not be considered interference, is the question we're asking Mr. Hefferman.
I wouldn't say it's interference. It's due process of law.
All right. Thank you so much for speaking to us, both of you. Advocate Modidima Mannya is a legal analyst and public commentator. Hefferman is a labor law expert from Hefferman Attorneys.